Welcome to Wyoming's Health Watch. I'm attorney Jason Oakes, and here you'll learn the most up-to-date information about dangerous drugs, dangerous products, and safety news with hopes that it just might prevent a catastrophe. Let's get started.
Good evening. Tonight I want to talk about a new development in the legal world that I think lawyers who are doing wrongful death and personal injury cases need to pay attention to, as this could have a huge impact on litigating future cases regarding or involving same-sex couples. Let me start with wrongful death. Those of us who've practiced wrongful death in the past, we know that in order to assert a claim as a spouse, when someone is harmed and ultimately dies from that harm, one has to be able to show that that harm occurred and the death occurred at the time the individuals were married. And if you cannot show that, it will be an automatic summary judgment filed by the defense, and you will lose. And many of us have been in that situation. There are sometimes ways around that, although they're not very many. For example, if in one state that acknowledges common law marriage, and that is where two people establish a common law marriage, and then they are later move or later hurt in a different state where common law marriage is not recognized, often in a new state where it's not recognized, as long as that couple established common law marriage in a different state and they have been injured in a new state, usually that new state will still recognize the common law marriage and give the spouse, the common law spouse, the same rights that he or she would have if they were otherwise married by ordained minister or via the state. But here's a new situation that I suspect very few lawyers, very few have come across, and this has to do with same-sex couples. We all know that same-sex marriage has been relatively new within the past couple of years, and it's still not legal everywhere, but it's becoming legal in most states. Even in my home state of Wyoming, there was a federal lawsuit that was filed a couple of years ago, and even our federal Judge Scabdall, found that it was a violation of the Equal Protection Clause of the Constitution to deny the right to marry with a same-sex couple, and therefore it became legal here in Wyoming. There was a case recently, and this is recently meaning within the last 2 weeks, in Florida, that I think will have a huge impact for us lawyers who are doing wrongful death litigation where we are representing or meeting with same-sex couples. It was a huge litigation down in Florida, and it was a tobacco smoking case against R.J. Reynolds and another big cigarette manufacturer, Philip Morris. And there was an enormous verdict of $157 million, $74 million of which was punitive damages against the two companies. And I'm sure this issue I'm about ready to share with you will be going up on appeal. But it will be very interesting to see how it comes down. The case involved a same-sex couple, two men, and one of the men had contracted lung disease from smoking cigarettes. But that injury had occurred before the same-sex couple was married. And for those of us who do wrongful death law, we would know that would typically be the end of the case, at least for the spouse. That doesn't mean that other people wouldn't have claimants, like the person who died, for example, parents or brothers and sisters. However, in this case, the spouse brought the claim and made a very novel argument that ended up winning the day. And he contended that because he was not allowed to marry his spouse under Florida law until 2015, when he otherwise would have married his spouse years before then, that he should be entitled to the same rights that any other spouse in the same circumstance who was otherwise married would have. The court let that issue go to the jury, and they let the jury decide whether or not that was a valid argument, and the jury found that there was sufficient evidence supporting the living spouse's argument that had the law allowed them to get married 10 years earlier that they would have gotten married 10 years earlier. The jury found in favor of the living spouse, and because of that finding, it allowed him to continue with his claims for wrongful death of the loss of his spouse. And ultimately, that jury awarded $157 million in favor of the living spouse for the wrongful death of his now deceased spouse. This is tremendous. And I think in a state like Wyoming, where we've recently, in the past couple of years, have had the ability, or the law changed, I should say, to have same-sex couples get married, this is something we're going to have to be thinking about when we meet with clients in this situation. We can't just automatically tell the client or the potential client that they don't have a case anymore. And if you do, you may be giving that potential client improper advice. In fact, I would submit you would be. Now there is precedent in Florida where the jury has decided in a different manner than is otherwise expected. And further, I suspect that this issue will go up to the appellate court, and then there will be case law that will address it. It wouldn't surprise me if it went all the way to the U.S. Supreme Court, especially because there are two major defendants in this case and a lot of money at issue, and they'll take it to the Supreme Court. They have the money to do so. So keep an eye out for it, but until that happens, this is a new area, a new argument that lawyers need to keep an eye out moving forward whenever they are consulting or meeting with same-sex couples or formerly couples in any sort of wrongful death or, frankly, any sort of personal injury situation or action. I hope this was informative for you tonight. Thank you for listening. Go to WyomingHealthWatch.com if you want to hear more podcasts. Otherwise, I wish you a great night.